Liberals Oshoma for more on Nnamdi Kanu's case. Mr. Oshoma, Nnamdi Kanu is saying there is no charge against him. He's refused to open any defense. Given the fact that the court has already overruled the no case submission and directed him to respond, how strong is his no charge argument at this stage? At this stage, does it carry realistic weight now?
Yeah, like I said last week, thank you, Nifemi. When Nnamdi Kanu attempted or opted to defend himself, I knew that he was certainly going to run into this kind of problems. Even for a lawyer, even though you have a right to defend yourself in a criminal matter, it is always advisable, even as a lawyer, for you to allow a colleague defend you. And considering the allegation against Nnamdi Kanu, I do not think it was advisable for him to have elected to defend himself. The first thing was he came to say he wants to call governors and politically exposed people as witnesses. And then today he said he has read through the charge and that there was nothing against him. And remember, the last time when the matter first came up and he was asked to defend himself, he said that he's objecting to the jurisdiction of the courts. And the court informed him that that stage had passed. That had been argued and dealt with. So he can't bring up the issue of jurisdiction again. And then he now also brought the issue of no case submission. The no case submission that had been argued by his lawyer and that the court ruled on. And now he's saying that he cannot open a defense because he has no, there is no charge against him. What that means, the implication of that legally is that he is resting his case on the case of the prosecutor. And that is dangerous for him. That's why the judge had to, look back a little bit, hold back a little bit to say, you know what, I'll give you time to go and consult legal expert on this. And after consultation, if you still insist, then for fair hearing, I would want you to write it down. Write it down and give it to the prosecutor. So that becomes, it is not just words uttered because they can be denied. It now becomes a documentary evidence against you when judgment is eventually delivered. I did say the last time that the judge might foreclose his defense if he goes on like this, because defense is not an open-ended opportunity.
Indeed.
There's a time for you to open a defense, and if that time given to you lapses and they are given a subsequent opportunity, and then most especially you now say that you have elected not to defend yourself.
Mr. Shoma,
because
the court now has given him a deadline, November 4 to 6, and it's also warned that written addresses will be taken if he doesn't act. What exactly happens next procedurally? What should we be watching for in the coming days? What are the most likely outcomes? Are we expected to see the trial now head straight to judgment or anticipate further adjournments?
Let me quickly break it down. Normally the procedure is, the prosecution will open their case, call their witnesses, and then after calling your witnesses, and then the prosecution will close their case. And if the defense feels that the case has not been established against them, they file a no case submission. If that no case submission is argued and overruled, then you are called upon to open your defense. If you still insist that you don't have a defense because you feel that there is no nexus linking the charge against you, what that means is you are closing your case resting your case on the case of the prosecutor. And so, or the case of the prosecution, and so in that case, parties will file written address. And since you did not call any witness, you cannot rely on fact. Your written address will be based on law only, because you can't be arguing fact that you did not present before the court. So you argue your written address on the basis of law only, and the parties will exchange written address. But that of the prosecutor will be on fact and law, because they had presented witnesses. So in that case, the next thing that you will see procedurally, the court had taken time to advise him and to educate him. And if he insists and put it down that there is no charge against him, the court will have no other option but to insist that written address be filed by parties. And in this case, remember the prosecuting counsel, Leonard Sik Awomola, had insisted that at the last time the court did rule that they were giving the defense 5 days to call their witnesses. But the court took cognizance of the peculiarity of his position on the ground that they had no legal representation. He has elected to represent himself. So, and that's why the court had to backpedal a little bit to extend the time within which for him to defend himself. Right. But if he still elects not to do that, then unfortunately, the parties will have to file written address, and then he will now have to bring an application subsequently if anything happens and he now wants to recall a witness. But I think it's not a good development for him, considering, I don't want to go into the merit or demerit of his application or the law because the matter is still sub judice.
Indeed.
But I think, legally speaking, it is not a good development for him, having ruled that he has a case to answer.
Well, I guess interesting days ahead as we see how this play out. Liberal Shoma, thank you for talking to us.
My pleasure always. Thank you.